Hey everyone, welcome to the Bold Today Show. I'm your host, JD Houvener, owner here at Bold Patents Law Firm, patent attorney, and it's my pleasure to be with you to talk about live Q&A on intellectual property, covering patents, copyrights, trademarks, and even some trade secrets, if we can get to it. So if you're tuning in live, we welcome you. If you're a first-time visitor, give us a like, share this with your folks on social media. I want this to be a vibrant community. We're here every week, so if you're watching this, you missed us, you're watching the recording, and you want to catch us live, we're here every Wednesday on Facebook, YouTube, and LinkedIn, 9 a.m. Pacific and noon on the East Coast. You'll be looking at me, and I've got two special guests today, and I've been trying to bring special guests most every week because, you know, you might get bored just looking at me. So I've got a business attorney and a colleague, his name's Rocky White with Lumina Legal. I'll bring him on in just a little bit. And then a client has agreed to come on and share what they are up to in the fishing industry and boating. So I'm curious to see what is up with him and kind of get some of your questions if you have any, if you have a product similar, okay? So I also want to do a quick legal disclaimer as I do each week. You know, I am an attorney, but this is not the forum to have a attorney-client privilege, right? By nature of you joining the broadcast, the webinar, I'm not your attorney and you're not my client, okay? But this is the place for you if you have questions related to process, you know, what a patent is, how to get started. Do I have what it takes, you know, to get started? Am I qualified? Is it eligible? Hypothetical situations, that's what this is for. So we'll try to keep it lively and fun, and we'll take those live questions as a priority. If we don't get any live questions, I do have a batch of 6 questions from our avvo.com community. I volunteer as an attorney to answer those in the field of intellectual property, and so we'll be getting to those at the end of the show if we do have time. Okay. So here, if you're ready to move forward and you want to schedule some time with us, I'll provide the link right here so you have it. This is a special link for our weekly live show, and this will get you tagged with that. So you get a copy of this free book, Bold Ideas, The Inventor's Guide to Patents. You'll get a PDF downloadable copy and version for your own library. Okay, well, without further ado, I want to bring on one of our guests. I want to bring on Terry Vance. Welcome to the Bold Today Show.
Good morning. Thanks for having me.
Good morning. You bet. Yeah, it's
Thanks,
always
JD.
fun having clients on, you know, and being able to show off some of the work we've done. So Terry, you're owner at Blitz Lures.
Yep. Yeah,
right.
I own Blitz Lures, based out of Tucson, Arizona. Was originally from the Midwest. My cousin owned the business back in the 90s and decided I needed something, you know, for retirement business. So I bought it from him, and I've done a lot of fishing my whole life. And so, yeah, it's getting into that business spurred the idea for a product that you guys helped me patent. So, yeah, it's been great.
And it's not a lure, right? It's
no,
not
and
a
it's
fishing lure. Okay.
Yeah, exactly. It's not a fishing lure. It's a device that you mount on your troll motor. So this device is, you know, as people would think, boats and everything is getting so technical and you know, technology advanced and using GPS. Troll motors now have a GPS function that allow you to lock the position of your boat. And by locking that position of the boat, that the troll motor has to turn its head to keep you in that position. Well, when you're fishing, you have a sonar device or fish finder that you're looking to find brush pile, fish, or whatever. They've come out with some what they call live sonar, which it gives you a visual live image of the fish swimming, you know, digital image of it in the water. So by putting that transducer on the troll motor and with it in SpotLock, you can't direct it to where you want to direct it. So my invention was to take that device off of the troll motor and put it on its own independent pole that is still mounted to the troll motor, but allows you to then adjust it independently of that troll motor. And you can do that through your foot, so that using foot switches, so that way you can keep your hands available to fish while you're adjusting it. Also have hand remote. So yeah, I went through a lot of design, you know, early versions of it to the latest version that I'm actually selling right now. Partnered with DD26 Fishing, and they are you know, marketing and selling the product and assembling the product for me.
Cool.
You know, Bold IP. You guys help with setting up the patent for that particular product. So we went through the patent search, which was good because it allowed us to look to see, is there anything out there currently in the marketplace. Then we filed the provisional patent, which in this particular case was critical to get that provisional patent in early. And then we filed the non-provisional later on, about 9 months later. And the reason why that provisional was very instrumental was because I found out after I filed the provisional that there was another company that was making something very, very similar. It's kind of strange. I'm in Arizona, they're in Arkansas or somewhere, and they've come up with a very similar idea. But they filed their patent application May 22nd of 2020. I filed my non-provisional on May 26th, 2020. So 4 days after they did. But I had the provisional filing of August 22nd of 2019, which took priority. So they actually, the examiner that was examining their application stated my patent in their final rejection notices that, you're not able to get this because of my patent was prior to theirs. So, if you've got an idea, you're not quite to the stage where maybe you want to file the non-provisional, but you need to protect the idea, get that provisional in. And what I'm finding now is in the fishing industry, it's imperative to get that in quickly.
Terry, that's huge. I didn't even know that coming up. So you are the living legend of file first.
File
right?
first,
File first, raise to the office. I mean, you probably would even admit that it's unknown who invented it first. It may be that they invented the darn thing first, but it doesn't matter because you're the one that took action and filed it, and so you were the one that wins. Thank you for mentioning that story. That's huge.
Yeah, and that's been, they've appealed. They actually got their initial rejection in August of last year. Then they got their final rejection in November. Now they had 2 months to get an appeal in, and then 3 months total. So we'll see here. That's like today, I think, is when they have to have that in there. So we'll see if they were able, send anything else in to try to. But, I've got some prior art back to March when I first started this, and I started talking to you guys here, I think shortly after March, probably April or something is when we started the conversations about getting something done. So yeah, very critical to get that done. Since then, they're coming out of the woodwork since I got, the patent office, released the patent under, gave me the patent, and it was pretty cool because it was released on my birthday, January 4th, 2022. So
we had that all lined up, Terry.
Yeah, I was going to say
right on your birthday. That's awesome. Let's take a peek at it. I got it pulled up. I mean, let's just show it off. I know it may be a little boring to some of the folks out there, but I'm going to nerd out a little bit and show this patent off. Patent number 11,217,216 to you, sir, Mr. Terry Vance. So we filed this just as you said. In the non-provisional was filed May 2020, but the kicker's down here. The provisional was filed on August 2019. So that is the date the Patent Office awards to the first to file. So the beauty of the provisional to get it in quickly tells the story. So this is the abstract, and we got a quick little picture. So as you're seeing, it kind of mounts on that, but it's separate from the trolling arm.
That's right. Yep.
And it allows you independent motion.
Yeah, and we patented, wired connection and wireless connection and mounted to the side of the boat, to the transom of the boat. And since then, there's filed like 6 cease and desists to companies that are out there trying to sell a product or are selling product that infringes on this patent. That's one thing when you have a patent that I'm finding out is it's my job to police and protect my patent. So ensuring that they're notified, and obviously if that's their sole business, they're going to try to punch holes in that patent as best they can with their attorney, because they don't want to license it from me, and and pay that money, and two, they they want to be able to do what they want to do. So that's been it's a little stressful, because they want to claim certain things, which to me doesn't make sense. Exemplary terminology in your patent, I think, is something that you guys put in there, which I think is going to be very critical in this case with my provisional, because they're trying to claim that I made significant changes from my provisional to non-provisional, which I didn't. Obviously, the art is different, but the functionality of the actual product is not different. So, So anyway, making sure that illustrations that you put in your provisional are such that they are illustrations, examples. Make sure that's clearly articulated, because I've not talked to my patent litigator yet on this, but I'm sure she would come back with the same thing, that this is all, there you can make some modifications or adjustments to the non-provisional just as long. So anyway.
Yeah, you're right. No, that's good stuff. Who are you working with on the litigation?
It's a firm here in Phoenix. It's Venjuris Law Offices.
I'll have you introduce me. No, that's great stuff. Yeah. Well, okay, let's circle back after the show on that. I want to bring on our another guest here, Rocky White, who's been waiting backstage. Rocky, I've been trying to get you on my show for a long time. Welcome.
Good morning. How you doing?
Yeah, good morning. Doing good. Yeah. So Lumina Legal, you're the owner there, and you guys do a business law, right?
Correct. Yeah. So I have a business law firm here in Seattle, and basically we help small business owners start up their business and then run their business, and just basically navigate any legal obstacle they come about in their daily operations. So now my clients are small businesses and medium-sized businesses here in the area of Seattle.
Love it. A lot of fishing in Seattle, right? You have any clients in the fishing industry?
A lot of fishing. Like I don't have any people in the fishing industry, but I need to get out there and look at the equipment on those boats.
Absolutely.
I feel like I need to see a video to really visualize your invention, Terry.
Yeah. We've got some videos out there, so we'll have to get some links out there. If you go to DD26 Fishing, or you go to my website blitzlures.com, you can check it out. So
all right, we have to real quick. You guys won't be able to hear the video. I want to go there. You can lead me there. So here's your site. How do we find you? Your transducer.
It's right there, Livefoot. It's the second product down to the right.
Livefoot. Oh, look at that, Matt. Livefoot with the TM on it. I'm going to bring Matt Close-up on just a second. So you've got patented. I love it. Sold via DD26 Fishing. So there it is. And that's probably a little smaller on your guys' screen. But there it is for $999.99. And they've got a separate website. So they're doing some
click over to his website, and then he's got a promotional video out there on it.
Oh, that's cool. Okay, I'm going to link out to that. And let folks watch that on their own set.
Yeah.
Okay.
Very cool.
Okay. Well, that leads me to one of the topics I wanted to get to. Trademarks, among many. Matt, as some people know here, he's our co-host, Matt Colta. Good to see you, sir.
Hey, fellas. Good to see you too.
Among things to think about getting a business started is trademarks for sure. So Terry, you got Blitz Lures. You've got, what was the name? Livefoot. Have you thought about protecting some of these names, some of these word marks before as you're going to market?
Yeah, I protected those. So I trademarked them. Actually, my litigator, she said I need to change the TM to a circle R now that I've got it federally, registered. So I just haven't done that yet because I didn't know I needed to do that. So
do it. Yes.
Yeah, awesome. So I've got both of those registered, Blitz Lures as well as Livefoot. The Livefoot was interesting because the actual trademark lady called me because I was trying to trademark two words, live and foot, that were like, items that are difficult to trademark together. So yeah, anyway, I can't remember exactly, but I got the trademark, but it was like a version of the trademark. I don't know all the details around that, but you guys probably know a lot more.
Yeah, I just looked it up. Yeah, so congratulations on the patent and the trademarks. I saw Blitz Lures registered in Class 28 sporting goods for the fish lures, and Livefoot is registered in Class 9, which is kind of like the electrical apparatus category. And you're right, that one is on the supplemental register, which
Yes.
means that they found it somewhat descriptive of the product. And so supplemental register is better than no register. But what it means is that, Terry, if you have that product registered at the USPTO for 5 years, we can always come back and claim that your product, Livefoot, has basically acquired secondary meaning and is entitled to registration on the principal register. So it's a good example.
Yeah, thanks.
There you go. Terry, so your product is you're using this other company, DD26. How did you line up that deal with them, and what's the upside of working with them?
Yeah, DD26 they provide a lot of boat accessories for the fishing industry, and he's local. He fishes a couple of my tournaments. They've got a CNC shop, so they can help with some of the components that I need made for the unit. He works with the other component supplier that I have up near that area, because I'm in Tucson, so they're about an hour and a half away. So he's looking for another product to be able to add to his portfolio that he could sell and market. And it just made a lot of sense, because I was building these in my kitchen, and my wife doesn't want me building these in my kitchen. And
Right.
we're starting. There's going to be a huge demand for these. The market, fishing market's huge. And there's no way I can keep up. I mean, during the day I work for Caterpillar, so I'm this is kind of my side hustle. So anyway, partnering with Dave Davis at DD26 was a great move. So they're doing all the assembly and everything, and he's got great distribution and dealer network throughout the U.S. So then we just
Rocky
moved yesterday to France. So somebody from France.
International.
Yeah,
talking, man, you're side hustling hard, man. Congrats on this work. I wanted to put Rocky on the spot. Rocky, what do you think? I mean, things, going through your mind in terms of, businesses working together, licensing, selling each other's products. What are some things that Terry should keep top of mind?
Yeah. First off, a non-business thing. I wonder how many meetings happen just fit on fishing trips. Like, hey, let's go on a fishing trip and talk about this, and hammer a deal out. I think you guys have like the perfect industry to work around that.
That's right.
Better than golf. Yeah, you got a lot of time potentially.
Yeah, exactly. You can just kind of fish and talk about it. But in addition to the rapport, the personal issue, I would make sure you guys have your contracts in place. I would just say it's always good to have written contracts just in general rather than oral agreements. So have all the details spelled out with your manufacturer, what how profits work, if there's any like split in percentage, or if it's just straight based on each unit, how many he's supposed to produce, all that stuff. I would just, when I talk to my clients, just tell them, like, as a baseline, just have all that stuff laid out in writing, because it preserves the relationship. Because when there's like vagaries in there and there's no details, then one person could say, oh, I thought it was this way, then the other side says, oh, I thought it was that way, and then it just can lead to arguments. So just when it's all laid out like that, it keeps the friendship going.
Yeah, and you're spot on. I mean, that's we have a verbal agreement, and what we kind of put in emails back and forth, but talk to Dave, and he agrees. We got to get it formalized into paper. So the unfortunate part is the attorney I'm using is also the same firm he uses. So we're going to have to find another one, or I don't think he's too happy with the guy he's working with at that firm. So, but anyway, I need to, we're working to get that all laid out and documented. Not to give either one of us an advantage, during this process. It's just to ensure that it, as you totally stated, get it written down, what you've agreed to. So if there's any issues, if I get hit by a bus, my wife knows what the heck's going on. And he's also protected because he's bringing in a lot of inventory and a lot of costs and things. And if I decide to want to sell the patent, he wants to have some type of, protection in regards to, first right of refusal to purchase it or something like that. So.
Exactly.
Cool. Because, Yeah, Rocky, I don't know if you're taking on new clients or if you're able to help anybody in Arizona, but I mean, who knows? Maybe you guys get connected and maybe help each other out, take care of some of those contracts. So
Yeah, sure. Mm-hmm.
Yep.
Yeah.
Rocky, I do want to showcase you a little bit before this shows up. I want to pull up Lumina Legal. I was looking at this picture and I was just like reminiscing. These pictures are beautiful. I was like, where is this? Is
Yes,
this
that is. No, that is Denali in Alaska.
Okay. I was like, oh my cow, it's gorgeous.
Yeah.
I can imagine it being maybe part of Washington, but no,
Right.
gorgeous part of the world.
Yeah,
You've been there before?
Yeah, we went traveling there. We went about maybe 3 years ago, and we went backpacking there. Like basically through all the greenery you see there, it's basically all swamps in the summertime because all the like ice is melting.
Yeah.
It's amazing, and so that's what inspired that picture.
Love it. Yeah, this is what it's all about, right? You work hard, you hustle, you work, you hope to enjoy, this world we live in. So I like that.
Exactly. And my firm's also a virtual firm, so we don't have a permanent office. We don't pay for high cost rental space. So it's all basically virtual. Meet with the clients online. This is from before the pandemic, and so my idea is like you can be there and you can be working, on whatever your business is.
Yep. Quick flash here of your services. You guys cover the gamut on business formation, contracts, and a whole lot of other stuff too. So good to see.
Correct,
including
yes.
intellectual property. Love it.
Yep.
All
So
right.
I do the trademark side, basically the soft IP, trademarks and copyrights, and not the patent side. So for that, probably go to you, JD.
Yeah, for sure. We'd be happy to help with patent stuff. And Terry brought up a lot of cool things. He's been with us for a while. He did the search, did the provisional, non-provisional. Now he's got the patent granted, and he's dealing with some of those things that come with that, right? You don't just get a pile of cash, a briefcase full of money when you get the patent awarded. You got to go into business, right? And you have to, as you said, act as your own police, right? The USPTO, they do not have police officers enforcing patents, and so you do have to go enforce it on your own. And he's doing that, which is great, a great testament to, that obligation, as it were, that hustle, determination you have to have as a inventor. So congrats on that, Terry. It's great to hear. Matt and Rocky, I want to see if you guys are up for answering some live questions from our AVO community. And Terry,
sure. Lightning round.
Yes, it's been a pleasure having you on, Terry. I'll put you backstage in case there's something that comes up from a live question. But thank you again for being on the show. It's been awesome.
Yeah, thank you. Appreciate it.
All right. Okay, so we got a first one is Akun Sahime. Sir, what is the first step you should take for your patent journey to get to your dream reality? See that? Look at that. We put that picture up of the green field and everybody's talking about, yes. How do you get there? Well, okay, I would say there's a lot of places to start. Educating yourself is important, right? Reading a book, learning about patent law, the differences between what a patent is and a trademark, when an idea becomes an invention, right? I say this a lot, and it kind of hurts people's feelings sometimes, but ideas are a dime a dozen, okay? Inventions are rare, right? So if you've thought it through, worked on it, got it to the point to where you could explain it to someone, even if you haven't built it yourself, but explain it to someone who could go build it. Now you've got an invention. That's something that now you're at the point to where you should reach out to a patent attorney. Click on that link above, schedule a free screening session, and just explore patent eligibility and patentability, okay? So that's kind of the first step. Know that patenting, as we just mentioned, is not the only piece of the puzzle. It's actually fairly small in the world, grand scheme of things. It's gonna help you. We found a lot, it motivates and excites a lot of our inventors and entrepreneurs to get out there, but you've got to hustle. You have to do what Terry just did. You saw him, you have to start a company, sell business, hire attorneys, hire professionals to surround you to move to the next level. So that's what I'd say, Akun. I mean, Matt, Rocky, would you guys add anything to that?
Yeah,
Rocky, go ahead.
Yeah, I would say kind of what you said. Make sure you actually have your idea correct and the invention is on its way. Before you spend all the legal fees, make sure the underlying invention is right, and then once that's the case, then you get the lawyers involved and get them to do that part.
Yeah, I would echo that sentiment, Rocky, and I would just say that successful businesses don't just happen, right? They take a lot of planning and a lot of forethought. So I think getting your patent attorney involved early and often, your trademark attorney, your business attorney like Rocky involved early and often is key, right? Because these processes at the United States Patent and Trademark Office, they take a long time. And you can kind of get ahead of the curve by getting a jump on the trademark applications, the patent work, before you actually go to market.
Excellent. That's awesome. Good, good. So Kuhn, hope that helps answer your question. If you have any follow-ups, please feel free to do that. We got a live question coming in from our Alvo community. This one's out of the great state of New Jersey, Fort Lee. So this is a medical device question. Let me pop this into the chat. And this is pretty good. So someone's hit some good luck, and either way, the way they're networking. A medical device manufacturer is interested in my invention that I haven't patented yet. So should I have a lawyer? Yes. Okay, just quickly. I received a response on my medical device that has a patent. Oh, that's it. But they're interested with another device that I have not patented. Should I reveal it to them and have a lawyer represent me for financial restitution? Then the manufacturer and have the patent for themselves. So there's some sort of prior relationship, it looks like. They've got a patent that they're already working with, or you've disclosed a prior patent, and you have a second one that is not yet protected. My thoughts, and maybe you guys could jump in. I mean, if there is an existing non-disclosure agreement, confidentiality agreement, maybe it does make sense to have a conversation about what it is. But I mean, the most conservative, the best answer is file first, right? Get that, at least a provisional application filed before you have a detailed discussion about the invention with that third party, especially if you don't have a non-disclosure or confidentiality agreement. Would you guys add anything else to that?
Yeah, I agree. I was going to say, be very careful before just revealing it without any type of agreement in place. Just kind of letting your secret sauce go. Be careful with it and protect that closely before you make any big moves.
Yep, completely agree. Even for friends and family, discussions around business, products, trademarks, I always just say it's best just to have a non-disclosure agreement in place. Most business attorneys are happy to do that for you. I'm sure Rocky does a lot of non-disclosure agreements.
Yes, sir.
Yep, well, that's good stuff. Thanks, guys. I think we have time for one more. Let me do one in trademark space. Let's see here. So 2 open questions. This one is, do you guys want to do Hawaii or Virginia?
Ooh, I went to school in Virginia, but my in-laws are in Hawaii. So I'm good either way.
Does that mean you want to avoid Hawaii at all costs?
Well, no. I mean, if they're buying, I'm going to go.
That's on the record. Hold on, we have a live question here. I'm going to skip to that. Lord Crunk. I'm a U.S. citizen. I love the name. I have a novel idea and invention to mitigate tsunami damage. Love it. Wow. How could I create a co-ownership of the invention with a foreign government or corporation from said country?
I'm going to go ahead and pass to my good friend, JD.
I love it. Well, so you want to share this with a government? I guess I would ask, first of all, Lord Crunk, do you want to make money with this? Okay. Do you want to make money off of what appears and sounds like, an environmental and a humanitarian invention that could certainly have a philanthropic side of it? If money is not your end goal, patents is not the vehicle, right? Patents is the vehicle to use if you want to make money, or control, okay? So if you want to try to make money, let's talk patents, get a hold of me. You want to file it, get protection in your name, and then you can assign it, own it, share it, just like any other asset, with a foreign government, with an individual, with an entity, and have fun with it, foreign or otherwise. I guess I'm speaking mostly to US law. But if your goal is just to help people and to get this to as many people as possible to save lives, I would just publish. I would look for the biggest, most reputable journal or news outlet, publish it, and then to start pitching and presenting it. Because when you publish it, the one thing you do is you prevent anyone else from getting a patent on it, because you have just published prior art. So you won't let none of the big, bad, ugly folks you might be worried about. There's no way they can get a patent on it and hide it, which a lot of big, ugly trolls have been known to do. Any thoughts, you guys, on that advice for Lord Crunk?
Yeah, I would say think about the whole relationship you want with the government. Is a co-ownership with a government entity the right goal you want? Maybe you want to do something where you keep it and maybe you lease it to the government, or you know, do something where you have full control over it. Maybe you could lease it to many governments. I don't know if a co-ownership with one government where they're say like a 50% owner, if you still have freedom to give it to other countries. I would say just rethink or just think about the general, relationship and the structure you want to have with the governments you work with to put this in place.
One quick note too, I work with a lot of inventors where their goal is to license to the government. It happens all the time. I mean, you look at the military, different branches there, they license products all the time from individuals. So that's a very viable way to go, is through licensing.
Yes.
Co-ownership, that may be a little bit blurred. You may not want to deal with the ownership, but certainly licensing to countries, government institutions, and private companies. It happens all the time.
Mm-hmm.
JD and Rocky, I got to jump here to a client call, but it was a pleasure
problem.
meeting you, Rocky.
Thank
you.
You too.
Thanks for being on, Matt. Have a good one.
Absolutely. Well, I think we're going to wind down the show. I just looked at the time. We're over. Rocky and Terry, I appreciate you guys so much for being on the show. I will have you guys back on again. I know we didn't have very much time to talk, but Terry, I wish you the very best on your venture. Let's get in the loop and talk about litigation and see if we can support you, and maybe get you some help on developing some written contracts with your business partner there at DD26.
Sounds good.
Rocky, great to have you on.
Thank you.
Thanks again for being on. I appreciate it. Have a good
Thank you,
rest of
guys.
your day.
Have a great day.
Happy to